commercial speech doctrine. And any attempt by the state to regulate that is subject to strict scrutiny, just like any attempt by the state to regulate what you would write in a newspaper article or post on a sign outside of your house or say in a public forum. Full protection under the First Amendment. Now, it's also important to note that even if we're talking about content that is determined to be commercial, so let's say your website or a brochure that you send out to clients or a billboard that you put on the side of the road, I mean, any of the sort of traditional, unquestionable forms of attorney advertising, even in those cases, the bar can't just do whatever it wants. It can't just willy-nilly put up whatever kind of regulation it wants. It still has to meet this test under the Central Hudson case. And it's where, if you recall back to constitutional law class, regulation of the content of communication is subject to strict scrutiny by the state. I mean, there's time, place, and manner qualifications on that, but at the end of the day, the state can't really regulate the content of communications unless it can pass a strict scrutiny test. When it comes to commercial speech and advertising, the test is intermediate scrutiny. So it's the bar that the state has to cross is a little bit lower, but it is still a bar. And so the regulators still have to show that it meets these tests. First of all, it has to show that the state meets the test for a substantial government interest. This isn't terribly hard for the regulators to do. Obviously, the state bar or the attorney regulators have an interest in regulating the, making sure that the justice system runs smoothly, fairly, etc. This is an easy part of the test to meet. The next parts are not quite so easy to meet. And it's interesting how often the states, particularly the states that have really struggled the most with trying to regulate on the edges of attorney speech, states like Florida, like New York, like Louisiana, Indiana, is how infrequently they actually meet these tests. They have to show that there's a direct advancement of the government interest. And so often the bars will actually put regulations in place and they'll simply say, you know what, we think this is bad, so we're going to regulate it. And really, they have to, I mean, under every test that's ever been laid out for the commercial speech doctrine, they have to target an identifiable harm, and they have to show that it's non-speculative. And typically this is done by producing studies and showing that there's been all of these problems with this particular form of communication. Like, for example, there's a number of states have restrictions on soliciting accident victims for a period of time after an accident. That's the type of regulation